Connor, our host this morning. Hi, Aaron.
Good morning, everyone. Welcome to Elder Law, Elder Financial Abuse, Prevention and Cures. Before we talk about that, I do want to thank our sponsors, NYSAR Trust Service, Quantic Bank, Advisors Insurance Brokers, and Beacon Communities. Thank you very much for sponsoring our webinar today. So I am, as I said, Aaron Connor. I'm managing partner here at Pierro, Connor & Strauss. I am a elder law, trust and estates attorney and a litigator by trade, and I deal with a lot of these elder financial abuse issues downstream. But before we talk about that, I'm going to introduce our illustrious panel. First, Peter Strauss, who's a senior partner here at the firm. Peter's been practicing for almost 60 years. He's a founding member of NALA, a fellow of ACTEC, distinguished adjunct professor of law at New York Law School, where he teaches a guardianship clinic. He is also the recipient of the New York State Bar Professionalism Award, which is a statewide award in a very, very competitive field. And he is a member of many boards. I could talk probably for hours just from his bio, but I think that gives you a good impression of who Peter is. We also have Ray Radigan today. He's head of TD Private Trust. He's responsible for managing trusts for TD Bank from Maine to Florida. He has 25 years in trust management. He's the past chair of the New York State Bankers Association, Trust and Investment Division, as well as its Trust and Estate Administration Committee. In addition, we have Liz Loewy, currently co-founder and COO of EverSafe, which monitors the financial health of older adults, protecting them from abuse. Prior to EverSafe, she was the chief of the Elder Abuse Unit of the Manhattan DA's office, known for the Brooke Astor case, prosecuting that case, and approximately handling 800 cases of elder abuse annually, which is a pretty staggering number. And last but not least, we have Marci Lobel-Esrig, founder and general counsel of Silver Bills, which she launched in 2015. Silver Bills assist seniors by receiving, scrutinizing, storing, and paying their bills. Marci has been a practicing attorney for over 20 years, both as in-house counsel and as an associate with a large New York law firm prior to that. So that is our panel for today. With that, I'm going to turn it over to Peter to get rolling.
Good morning again, everyone. This is an awesome subject. Financial elder abuse, as well as other kinds of abuse, is rampant, and I'm going to skip through some of the early slides quite quickly, but I want to start with a story, which is this slide identified as a problem, and this is a true story. A couple of years ago, I was at my out dining with a friend, and my cell phone popped up with this message, and it said, "Hello, how are you doing? I hope this message finds you well." Of course, you can immediately see that there are some language issues here that might have been a clue. Please get back to me as soon as you can. It's a matter of urgency. I'm in a terrible situation. I'm here in Manila in the Philippines for a conference. On my way back to my hotel, I was robbed at gunpoint. My wallet and other valuables were stolen off me, leaving my passport and life safe. I will appreciate whatever you can assist me with. Let me know if you can be of help. Thanks, Glenda. Well, I had a friend named Glenda. She was on her way to this conference from Singapore, where she was visiting her grandchild's fiance's family. And I decided I was going to help her. In fact, Glenda was sitting across the table from me in the restaurant. And I said, "I'll help you by picking up the dinner check." This is the kind of stuff that people are getting in the internet. Next slide, please, Bruce. So this slide is just a quick listing from the FBI's Internet Crime Complaint Center. This is just one of the kinds of financial abuse, and you can read it. It just gives you a sense. There are lots of information sites out there that you can see similar analyses of what's going on. Next, please. So this gives us a sense of who are the victims of financial abuse. Only 1 in 44 cases are reported to authorities. That's pretty sad. People are afraid. Who are the victims? Well, disabled persons, persons with cognitive incapacity, dementias, including senile dementia, the Alzheimer's type. But it's not just disabled persons, and this is a very important point. Loneliness and depression are also causes of people being targets of elder financial abuse and other kinds of abuse. Who are the abusers? Just very quickly. In almost 60% of elder abuse and neglect incidents and other forms, the perpetrator is a family member. 2/3 of those are adult children or spouses. And this fact really forms an essential part of some of the points that I want to make today. Next, please. I think it's important to note that people who are the victims of financial abuse have a 300% higher risk of death to those who are not victims. Costs, you'll see a lot of statistics out there just from the reports that I've looked at from the FBI in 2018, internet theft, fraud, exploitation, based on almost 352,000 complaints, total 2.7 billion. And the next slide is a chart from the IC3, that's the Internet Complaint Organization run by the FBI. You can see that it's almost 2.8 billion just in internet financial abuse. And there's lots of other kinds, as you will hear this morning. Next, please. So this slide shows you some of the signs and symptoms that we ought to be looking for, and I leave you to read that on your own, because I want to get to some of the things that I want to point out we should be looking at. Next, please. So this is where I think we all need to focus our efforts. Not just the elder law and estate planning attorneys, but the care managers and the financial planners and the bankers. We've got to make financial abuse part of the planning. We have not been doing that sufficiently. And among the things that we as planners, no matter what your professional background is, but particularly elder law and estate planning attorneys, have the client focus on who their fiduciaries ought to be. Family members, who are the cause of a great deal of financial abuse, are the people that we often usually select as our trustees, our agents under power of attorney, the people we put on our joint bank accounts. So we've got to make this issue a focus, and most clients don't want to talk about this. Trusts are becoming a much more important part of estate planning. And you'll hear again from Ray a little bit later about why trusts are so important. Now, when we do trusts, frequently, particularly with Medicaid asset protection trusts, where you can't allow the use of the capital, the principal of that trust, to be used for the income beneficiary, who's going to be the Medicaid application, we then allow that distributions can be made to other family members, perhaps the children. And if we're making the children or other family members the trustees with that distribution power, there is the potential for abuse. So we need to consider alternatives to allowing that total control to be in the hands, as the statistics show, of people who could theoretically become financial abusers. So maybe give those distribution decisions to some independent trustee or require a third-party consent. Make sure that your financial advisor, your CPA, or the attorney has copies of the trust accounting statements. Usually trustees could be asked to do an annual report. Sometimes there are court filings. In guardianships, for example, there are annual reports. But again, think about the various mechanisms that could be used to flag financial abuse in the case of trusts. Next, please. The other important tool that people adopt in estate planning is using a power of attorney. Here you appoint an agent. Sometimes you appoint more than one agent. If you're going to appoint 2 or 3 children to be your agents, if you're not married at the time, you have the choice to say they could act independently, or you could require a majority vote, or you could require unanimity. Normally, it's more efficient and a more effective tool to have just one agent be able to handle ordinary transactions. But you need to think about that. The power of attorney under the New York statutory form allows you to appoint a monitor, someone who has the power to look at the records, to obtain information, and be a check on misappropriation of funds. Typically, clients don't check the box that says I appoint Bob Smith as my monitor. I don't need to do that with my kids. My kids are trustworthy. Yes, look at the statistics. This is a hard conversation, but advisors need to have their clients discuss this. And if you're the planner, make sure your notes and your records show that you did discuss the monitor with the client and they did not necessarily accept it. Next, please.
2 minutes, Peter.
Okay. There is also in the power of attorney a statutory gift writer. We need the statutory gift writer perhaps to do estate planning, financial planning, asset changes, and maybe even most importantly, to do Medicaid planning later on. That's a awesomely powerful tool to put in the hands of your agents. Your children, again, going back to those statistics, put you at risk if they turn out to be in the wrong side of the line of who's trustworthy and who's not. So maybe if you're going to empower your agents to make gifts, they should either be required to act unanimously, have a third party's consent necessary, and these are important things to think about. Now, I want to just point out, I only have a minute left. Medicaid changes in New York that go into effect October 1st, and you can see our webinars and outlines on our website, are going to impose a look-back period and a potential waiting period for Medicaid home care benefits in New York. Next slide, please. What does this do? It means fewer people are going to be able to get Medicaid home care benefits. The loneliness factor will be increased because you don't have a home care aide to prevent fraud. Sometimes the aides can be a problem because the aide could also be taking mama to the bank and withdrawing $750 a week in cash. So we need to do this. Last slide, please. All right, very quickly, budget cuts. We're going to see dramatic, the final slide, please, Bruce. Before the pandemic, we were made aware that there was going to be a $6 billion budget shortfall in New York State. As a result of the pandemic, we're going to add $13.3 billion to the New York State deficit. This lost revenue, as the budget director said, as you'll see that quote, are going to minimize and diminish government benefits and not-for-profit organization benefits to assist people to avoid financial abuse. Got to think about that. And the reduced benefits in government programs are going to become a serious problem. That's my time. Aaron?
Great job, Peter. Thank you very much. A lot of good stuff there. With that, we're going to turn it over to Ray Radigan to hear about the bank side of the Trust and Elder Abuse Administration. Thanks, Ray.
Audio?
I think you're on mute.
Okay, thank you.
There we go.
Good morning, everyone. And what I thought I'd do today is look at the bank or the financial institution's perspective in protecting people from future financial exploitation in the world of elder abuse. Peter went through the methods of financial exploitation. I'm not going to spend any time there, but again, you have this slide that lists the various activities that work there. But if you go to the next slide, what I want to do is first talk a little bit about on the top there, as counselors for our clients in terms of minimizing potential financial exploitation as they get elderly. You provide advice in terms of you want them to avoid isolation, you want them to keep in contact with family members, you want them to stay active and so on. But what I really want to do is spend some time on the bottom bullets there, and that is how financial institutions have stepped up and provided some protection in the area of elder abuse and financial exploitation. And we can do that in simple ways like direct deposit. Direct deposit has been around for years. Physical checks are almost a thing of the past. So to the extent you have clients who have Social Security checks, they get pension checks, direct deposit doesn't eliminate potential financial exploitation, but it certainly eliminates the chance of a physical check being stolen or what have you. Also, banks, other financial institutions offer alerts to trusted family members with regard to accounts. I think Liz is going to get into this in a lot more depth. But if there's a suspicious activity, whether there's withdrawals exceeding a dollar amount or percentage amount or whatever the case might be, that's a red flag, and that could be a potential for financial exploitation. And there's software programs out there that could monitor this. Getting back to the family itself, I've seen basically two scenarios. One is you have the client who has a brokerage account, has a bank account, and maybe a trusted family member also has access to that account, and they can make withdrawals when appropriate. They can read financial statements, or the client might say, look, I don't want to give my trusted family members necessarily physical access to the account, but maybe they should have the read-only access where they can read my financial statements and be a second pair of eyes, if you will. If something goes wrong, they can step in and do the proper thing to protect the client in that regard. The last bullet is extremely important because until relatively recently, banks were afraid of disclosing suspected financial exploitation activity because they ran the risk of basically the employee themselves and the firm being subject to civil liabilities because they're violating some privacy laws. Well, now there's protection on both ends. On the federal end, it's the Senior Secure Act, and New York has legislation as well that will basically protect banks and financial institutions if at the end of the day they report suspected financial exploitation activity. They must do so in good faith, and they must do so by using reasonable care. And usually this report is made to the Adult Protective Services. What's interesting is on the federal side, training is required for employees. So at TD Bank, we go through an annual training session that helps us not only identify suspicious activity, but report that activity when it's appropriate. And we have protocols in place that basically tells us, again, what to look for and also when to report it and the method of reporting it as well. If you go to the next slide, just one quick thing. Adult Protective Services, what's interesting there is once you report the incident there, what they do is they follow up. And one way they can follow up is they talk to the client themselves and ask for the client, hey, if you give me access to your financial information, I can look into this and see if financial exploitation actually has been made. The problem there, however, is in many situations, the client might not have the capacity to make that consent. Well, under local law, Adult Protective Services can also basically get that financial information on their own without the client's consent. And again, this is as a means of protecting the client when it comes to potential financial exploitation. This slide talks about the power of attorney agreement. I'm not going to get into the power of attorney agreement per se. We have the statutory short form in New York. Agent obviously should be trusted, broad powers, narrow powers. Peter made a good point. I think having a monitor could be an excellent added protective device, but not everyone is willing to do that. But what I want to do is just quickly talk about some of the problems that you're seeing with financial institutions, quite frankly, when it comes to the power of attorney agreement. Right now, the law provides that banks generally must honor properly executed power of attorney agreements. The problem is, quite frankly, there's no damages, there's no attorney fees if the bank in bad faith, for example, decides not to honor a power of attorney agreement. And it surprises me because there's no damages. I'm still hearing stories about certain banks in certain instances being hesitant to accept power of attorney agreements. And some of them might say, hey, you know what, this is old, it's stale. We'd feel much more comfortable if you use our forms of power of attorney agreement with regard to a particular bank account. That's all well and good, but many times a client, again, doesn't have the capacity to do that. So banks are not only hesitant in certain situations to accept regular power of attorney agreements. Those are power of attorney agreements that are effective immediately, and most of them are. But imagine presenting a springing power of attorney agreement to financial institutions. Springing power obviously means it does not become effective until the happening of a future event. And typically that is, for example, on the written certification of two physicians saying the principal no longer has the mental capacity to manage their financial affairs, right? My point is now you're adding another complication to the mix. I think in certain instances, springing power of attorney makes sense, but now I'm arguing that possibly financial institutions could be that much more hesitant. The point I will make here is that there's pending legislation. There's pending legislation because right now your only basically remedy is if a bank does not honor a power of attorney agreement, under general obligations law, you can initiate a proceeding to compel them to honor the agreement. There's no damages, there's no attorney's fees. There's legislation now pending that would allow for, if the bank unreasonably does not honor a power of attorney agreement, they could be subject to damages, they could be subject to attorney's fees. That's been pending for over a year and a half, to my knowledge, not passed as of yet. By the way, the legislation would also say that if the bank in good faith honors a power of attorney agreement, and then it turns out for whatever reason there's fraud or whatever, the bank should be held harmless. Obviously, it's a factual situation. But banks today even can withhold honoring if they think in good faith there's evidence of fraud, undue influence, or what have you.
Right,
But in the next slide, yep. Last thing I'll talk about is, and Peter alluded to this, we're seeing a lot more trust being used as a vehicle to protect clients from financial exploitation. And the reason trusts are great, they can be more comprehensive. I mean, they can address not only asset management, but they can address, is there a preference for home care versus nursing home care? Who do you want to retain as a physician? Who do you want to give access to medical records, what have you? So, and with the New York and the federal estate tax exemption so high, we're seeing more people in New York create trusts for non-tax reasons, and this is one of them. Another non-tax reason, and then I'm done, is we're seeing a lot more people set up trusts as a means of avoiding probate. What's happening in New York, look, I love the surrogates court. My dad was surrogate in Nassau County for 22 years. The surrogates court today probably has half the staff they had 25 years ago. And what used to take weeks to have something admitted to probate now can take months, if not longer. And now we have the pandemic situation where our courts are virtually closed. So I'm hearing from a lot of New York attorneys, not only are they setting up living trust as a means to protect their clients from potential incapacity down the road, but to avoid probate as well. Okay, Aaron, that's my story. Sticking to it. Back to you.
Thank you very much, Ray. And I would say my experience, that's 100% accurate now with the pandemic and the courts closed, that use of a trust has become even more valuable than it was before. With that, we're going to turn now to Liz, COO of EverSafe, to talk about how we protect seniors from some of these activities. Thanks, Liz.
Oops.
Thanks so much, Aaron, and thank you to Pierro, Connor, and Strauss for inviting me to chat with you guys today about elder financial abuse. As alluded to in my intro, I'm here wearing two hats. One is as a former prosecutor. I did work at the Manhattan DA's office. I ran the domestic violence unit, and then helped to found the first elder abuse prosecution unit. We had all kinds of specialized units, child abuse, sex crimes, domestic violence, and nothing focused on elder abuse. But we started that unit under DA Morgenthau. I ran it for 18 years, kept some of my own cases, saw that financial crimes were the most common form of elder abuse. And by the way, just to clarify, I did not handle 800 cases a year, but my unit did. So I wanted to just put that out there. I would have been really busy if that was the case. I left the DA's office to co-found EverSafe, which is a fraud monitoring service that's focused on families and in particular older adults. We monitor for fraud, scams, identity theft, and what we call age-related issues. Howard Tischler is my CEO. He is my co-founder, and he has an impressive background in business and technology. I met him when I was in the DA's office, and his 80-year-old mother was scammed. Her finances were a wreck. He found out late, as most folks do. He was in touch with his mother. He was in touch with his mother's advisor, but didn't know about what was going on for quite some time, and then stepped in. I met him, we chatted about what was going on, and he told me what he thought could be done, and thus EverSafe was born. But I'm going to talk first about the problem. If we could go to the first slide. Thanks. These are just some more statistics. I think one of the surprising ones is that a recent study from Department of Justice and the University of Texas found that of all the forms of intentional elder abuse, elder fraud has the lowest survival rate. Now, you may find that surprising. I did not, because so many of the older victims who were defrauded, who were scammed, passed away. We had a rule in the elder abuse unit that you had to meet the victim, even if they suffered from dementias like Alzheimer's. But some of the victims we could never meet because even one lawyer who had lived through 3 heart attacks passed away when his longtime caregiver exploited him. Victims lose on average $120,000. Caregivers, this is a big issue for caregivers, adult children who really need to keep an eye on their immediate family's finances, but they want to keep an eye on their parents' finances as well. They lose a lot of money. They try to make their parents whole. They lose money when they take off from work to buy medications. So you see that amount. And the total losses, according to Bloomberg, and I think this is low in this country, is $37 billion. Next slide. Next slide, please. More about the problem. I want to address this first as a prosecutor, and then I will talk about EverSafe because I left the DA's office to work on this problem in a preventative way. And I know the title of this is called Prevention and Cure. So first, more about the problem. And you heard about this from Peter and from Ray. There are so many challenges that law enforcement and civil attorneys face with these cases. The biggest is probably diminished capacity. Neurologists and other scientists say that who have studied capacity and financial capacity have determined that you start to lose it in your early 50s. So it can happen quickly. There's no bell that goes off. So it's really important. You heard about advanced planning from Peter and from Ray. It's really important to plan for this. Greed is a big issue, and yes, it's mostly family, as in the Brooke Astor case. So it took us a long time to investigate and prosecute this case. The trial itself took a long time. Mrs. Astor's only son was convicted, and I'll talk more about that in a moment, but one of the things that you should know, and I think is misunderstood, is these cases can be in criminal court and civil court, as the Astor case was at the same time. And this case involved the misuse of a POA. He was convicted, by the way, her only son, and the case was atypical, perhaps in the amount of money that was stolen, but typical in that it involved family. He was her healthcare proxy. He was her power of attorney. And by the way, for those of you wondering, there was gift giving in that power of attorney that he abused and misused, which allowed her to make gifts to him. But he took advantage and abused that POA. And I have an issue with powers of attorney for that reason. POAs, of course, have access to funds. Talk more about that later. She had diminished capacity. She actually was diagnosed with Alzheimer's. That's when he started scamming her. Her banks, her investment firms, they did not pick this up. And these are all things in common with every other case that ADAs in my unit had. There was concurrent civil and criminal litigation. It started in guardianship court. It ended up in surrogates court. She passed away before the trial. All of these things are common for law enforcement. The defense attorneys often drag out cases so that we have to prove it without calling the victim. Next slide, please. I am always asked when I speak to elder law attorneys, advisors, all kinds of folks, what are some of the signs of diminished capacity so that when you're doing advanced planning, you can plan for it. I'm not going to go through these now, but I work a lot with Dr. Daniel Marson, who's a true expert on diminished capacity, and he has listed some of the signs, and they are here so that you know. Next slide, please. From my viewpoint as a former prosecutor, this is why I think there were so many cases. Banks faced real challenges in finding these cases. Most of the cases in the elder abuse unit went on, and we did a survey. We looked at cases over a period of time, went on for about 14 months before they were picked up. And they usually, unfortunately, weren't picked up by banks or investment firms or credit unions. They were usually picked up by family members or close friends, but 14 months is a long time. Why is that happening? And by the way, I give a big shout out and I give kudos to TD for focusing on this subject. But here are the challenges banks and firms and credit unions face through no fault of their own. Scammers steal across accounts and across institutions. They don't usually take, the first time that they start small, they're not going to steal a huge amount from one bank. They'll test, and then they may take an amount from a bank, then go to an investment firm, then maybe hit a credit card, and they do it over time. And you may not know, and I know I have financial services professionals in the audience, that a bank can pick up the phone and call an investment firm to talk about John Doe. Gramm-Leach-Bliley and privacy regulations preclude them from doing that, forbid them from doing that. The other problem is that alerts, for the most part, are static. So at my big bank, I can put in an alert, but it's for an amount over or under a number. It's static. Maybe I'll choose $500 for a transaction or $50, but they're not personalized. So when I was in my 20s, I used my debit card a lot at 2 or 3 in the morning. Maybe not so much now, and maybe less when I'm in my 80s. So that knowing your customer changes over time, and alerts generally are not personalized. And also, as I said, banks and firms can't share information. Next slide, please. And I know I'm running through these, but I want to get to a little bit about EverSafe. Banks and firms are on top of this. Many of them now recognize that abuse in later life, abuse against vulnerable adults who are younger, this is not just a senior issue, it's important. So the regulators are on it. There's something called the Senior Safe Act, which applies to all financial institutions, that says, and I hear him paraphrasing, if you train your folks on elder financial abuse, on the red flags of elder abuse, on privacy, you will get immunity in civil proceedings, say if you report the wrong case. That's a big incentive. Next slide, please. There are FINRA rules that apply now to broker dealers, and many advisors and banks are following these rules. You heard Ray refer to one. There's one which allows them to place a hold on a disbursement, which looks like it's related to suspected elder financial exploitation. And another rule, a great rule, 4512, which basically says you must take steps, broker dealer, to get the name of a trusted contact. So if there's a problem on the account, we can reach out, and they're supposed to do that when the account is open or updated. And I know many banks, perhaps TD and others, are now instituting this rule. But a trusted contact should be more than a name in a file. And by the way, it doesn't just apply to an older client who may get dementia someday. I tell advisors, broker dealers, and folks at banks when I do training, don't make this all about dementia, please. Make it about if you're traveling in Europe as you retire, we need to reach out to someone if we see some possible scam activity. Next slide. So a little bit about EverSafe. I am a true believer, this is the reason I left the DA's office, that technology will solve this problem. And I think that banks and firms need to do more to identify more of these cases earlier. And obviously, I think they need to work with other fintech companies like EverSafe, perhaps like Silver Bills, and you'll hear from Marci, to find these cases. So what is EverSafe? I told you we do financial monitoring, but we look across accounts and across institutions. We analyze bank accounts, whether it be checking, savings, investment accounts, retirement accounts. We look at credit cards. You can connect any of these things. And we look at credit, of course, but I think there's a big misunderstanding that looking at your credit report is going to find all your financial abuse. In fact, as a prosecutor, I will tell you that only a minute number of cases started in a credit report, okay? Many of the cases we got never showed up in a credit report. So I'm glad people know about credit report monitoring and identity theft, but this is really a much bigger problem. We use machine learning to develop a personal profile of that customer, not just at one bank or one investment firm, but across those accounts and across those institutions, and alerts are based on that personal profile. When we identify suspicious activity or erratic activity, and as Peter said, it's all about erratic activity, we notify not just the member, but anyone they designate. Okay, so we've heard a lot about POAs. We support POAs. Remember, POAs have access to money. That's why Anthony Marshall, son of Brooke Astor, got to steal. Okay, we are read-only. You heard about read-only from Ray. We support POAs. We support trusts. If you want to give alerts to your adult child and a POA, a good idea. Or a few children, a good idea. Or a CPA, or your trust and estates attorney. You can do that. We alert any number of people, and I believe we're the only service out there that does that. And of course, we provide expert remediation. Next slide.
About a minute and a half.
I appreciate it. These are some of the alerts that we have at EverSafe. This is just some of them. We alert to changes in spending. A change in spending on food can be very important. If you know your parent is spending a lot more on food, it could be a caregiver who's stealing. If they're spending less on food, it could be that they're depressed, and that's a problem. They're isolated, and that could also be a problem, not just about fraud. So we work, our partners, of course, are elder law attorneys. We go direct to consumer. I'm very pleased that some of our partners are leading banks and firms. We have contracts with Fidelity, Morgan Stanley, UBS, Raymond James, that has a great longevity program. Perhaps we can work with some of you. We have pilots with the Department of Justice. One actually focuses on guardianship courts. So in 2 major cities, EverSafe will be ordered by the judge for the guardian or conservator to make sure that there's no erratic activity going on, and also to make sure they're doing their job with respect to that protected person. We have other Department of Justice grants. We've been fortunate that we got an ARP Consumer Choice Award 2 years ago for our technology. Next slide to finish up. We also give out not just alerts about erratic activity, but also so that folks can stay on top of their family finances. We're not just read only, but we really feel that this is about staying independent for longer periods of time, especially during COVID. You know, this virus is hard because adult kids like myself who want to visit older parents can't. And so maybe a parent needed their adult child's assistance to figure out something strange that was going on their account statement or an email they got. That's not happening. That's why fraud is increased during COVID. And that's why technology has to be used. So as Ray said, an extra set of eyes on our parents' savings. You know, I know advanced planning is tough, but we support POAs, we support guardians, we support those monitors that Peter Strauss was talking about. Last slide. If you're worried about whether you're a reporter, because not only are the regulators on the things that I mentioned, but reporting is different in every state for adult abuse and for elder financial abuse. Our site does have a map. I'm asked about this a lot. You can click on the state to see if you're mandated to report or not, and hopefully you will report. I know there are suspicious activity reports that banks file, but they are not shared with consumers. EverSafe is shared with consumers. Again, I thank you for having me here today. I think there's one more slide while I say goodbye. These are just some tips on things you can do with advanced planning during COVID. And Aaron, thank you. I hope I didn't go over my time. I think there's a last slide here, and I'll say goodbye and wait for questions towards the end. Thank you.
Great stuff, Liz. Thank you very much. A little
Thanks,
over, but I think it was worth it. A lot of stuff to learn there and to be aware of. With that, we're going to turn it over to Marci. So she's going to tell us how she really is boots kind of on the ground helping seniors with their daily bills. Marci, it's all yours.
Thanks very much, Aaron. I appreciate it, and I appreciate the opportunity. My name is Marci Lobel-Esrig. I'm founder and general counsel of Silver Bills. I was a lawyer for the New York Mets baseball team parent company when the Bernie Madoff scandal occurred, and I rapidly became really an expert in that aspect of financial exploitation when my company lost $500 million and almost the entire 401k of the company. And at the same time, my elderly aunt was aging in her home, and she was struggling with this issue of managing her household bills. And I did a lot of research into the overlap of those two areas, and I discovered that there was no national technology-enabled solution to managing household bills, and that often when older adults turn to people who were entrusted to help them with this issue, they were financially exploited. The next slide, please. In the next slide, just quickly, some of the issues that might necessitate needing help with managing household bills, the typical physical issues, issues of visual acuity, and when older adults are hospitalized more, they may not be able to manage all of the details that are required to age in place. Next slide, please. And what are the consequences? We're not talking about a cosmetic issue. We're not talking about an informal problem. We've seen all of our clients, and prior to enrolling with our services, experience all of this: eviction or foreclosure, termination of vital services like electricity, and financial exploitation, late fees, etc. The next slide. So what happens when individuals turn to people for help? I'm not going to go into the specifics of each of these cases, but on and on and on. They're financially exploited. They ask a neighbor, and that person comes into the home and writes a check that's not been authorized. They ask someone who's supposedly a professional, like the case of the PTA president in my own community who is in jail now because she was helping an individual for years write his checks. And years later, his adult daughter discovered that she'd been writing checks to cash for tens of thousands of dollars. The next, please. And one of the main solutions up until we started Silver Bills for this problem were in-person household bill management services. So someone would come into the home, whoever that might be, and they would help write checks, they would read the bills, etc. What are the problems with this? And prior to the pandemic, I used to speak about these problems in very real but general terms. There's no way, and based on my experience, I hate to sound like an untrusting individual, but I saw how high net worth, sophisticated individuals were financially exploited by Bernie Madoff. So I have to be very scrupulous about who I'm trusting, especially with potentially compromised or lesser able to defend themselves older adults. So potential for theft of personal effects. When you have someone come into the home, are they stealing jewelry? Are they stealing gold coins? What are they doing? You cannot monitor for that. And there's no real-time data in check writing. So there is a lag between when a check is written and when the discovery of unauthorized funds occur. And that's a problem. And third, now, because of the COVID pandemic, it's just not safe from a health perspective to have someone come into the home unnecessarily. And that's why fintech alternatives to this in-person model are so crucial in protecting particularly older adults who are the most susceptible to the health issues that we're currently facing. The next slide, please. So what we've built proprietary software at Silver Bills with our team, and what we do is we receive scrutinize, store, and ensure that our clients' bills are paid correctly and on time. And our clients don't have to manage this process on their own anymore. We built this product specifically for older adults, but I often say we don't discriminate based on youth. So we have clients throughout the United States of varying ages, but no computer use is necessary. And we have account managers dedicated to each client who form relationships. And as many of the previous presenters have discussed, form a team. So there's a check and balance potential that we've provided to our clients, and that is very valuable in preventing financial exploitation. Clients pay an economical flat monthly fee. We have a variety of partnerships which provide discounts. And in New York City, the Department for the Aging is actually paying for our services for qualified individuals to receive them for free. The next slide, please. So the process, I'll go through this very quickly because I'm mindful of the time. It's very simple. If you want more information, our website has a lot of helpful videos about the enrollment process. We need a signed agreement. A power of attorney can do this as well. We need one sample of each bill. And then going forward, we get everything directly. And our clients can just relax. We will take care of that based on historical parameters and using our proprietary financial technology solution. So they do not have to use computers or technology. We do this for them. And everything can be done over the phone or through the mail. There's no need to turn on a computer to benefit from our services. Next, please. As I mentioned, we have a partnership with the New York City Department for the Aging. They pay us to provide free services to New York City residents, transitioning from their in-person volunteer model. Since 2019, we've had this relationship with the New York City Department for the Aging. The next slide, please. Just some quick alternatives. You know, there are apps, et cetera. We are not simply an app. That is the difference here. We have product market fit with this population, which means we're sensitive to the needs of older adults, and there is someone on the other end of the phone. It's not simply an app that you need to function with. It's human beings. It's business reply envelopes. So if our clients want to transmit anything to us in the way of the US mail, they simply put it in an envelope that we provide them a supply of. No need to write on the envelope, no need to stamp it, it's in the mail. And again, you know, the other alternatives of in-person solutions are less secure. On the next slide. Just if the client wants to use technology, or if they have provided in writing that a third party can access their read-only documents, they can see all of their bills through our interface simply by pressing a button, and all of the historical documentation is in one place. The next slide. We also provide a monthly budget and accounting of what's been done, and this can be sent in the mail in paper form to clients or their third-party authorized representatives, or it can be accessed on the computer. About 10 to 15% of our clients want to get paper statements in the mail, simply of this consolidated version of what they've spent in that month. The next slide, thank you. The market, so it's approximately 17 million older adults do not use the internet. And that we are providing a technology solution that bridges this population between the technology and the non-technology enabled population, and helping protect them with this proprietary software solution. The next slide. We have a variety of partnerships that I mentioned. The next slide. I think it might be the last one. This is the contact information. I tried to be as quick as possible to be mindful of the time, but please feel free to reach out with any specific questions. And thank you again to Pierro, Connor, and Strauss for hosting this event.
Excellent. Thank you, Marci. Again, I'm Aaron Connor. I'm just going to talk a little bit about what guardianship looks like on our end, because some people may not actually be aware of what that is. We've talked about, some things to do to get out in front of it. So when people fail the plan, like as Ray said, you can use a trust. That's really the best way to go. Peter talked about powers of attorney. Those are good steps. Doing those things doesn't ensure that there will never be a guardianship, but more than 95 or 99% chance that you will not need a guardianship if you go out and do those things. Certainly when power of attorney is lacking or a trust is lacking, there's a much higher chance that we're going to need a guardian. We need a guardian to appoint somebody to handle what's called person and property. Essentially, person is a healthcare agent making medical decisions for the person, but it also may be where they live and who gets to visit. That's a very common thing that happens in guardianship, visitation issues. And then property, again, is generally like a financial person, power of attorney, may determine whether they're going to apply for Medicaid, excuse me, and what type of care they're going to receive or how they're going to pay for it, really. It doesn't just happen to elderly people. I've done a number of guardianships, unfortunately, for young people who have been in an accident or have some form of diminished capacity. It is litigation. It involves going to court and involves the appointment of a court evaluator and an attorney for the person who we're saying is incapacitated. All of that becomes very costly, and generally when the person has assets, comes out of their estate. So it's not an efficient process. I mean, it's quick in terms of how courts work. We have to have a hearing generally in 30 days. We could put that off if we need to, but generally we're trying to get there as soon as possible. Next slide. One thing that you can do in a guardianship to mitigate elder abuse, and really what we're doing is this is a reactive process, okay, guardianship. It's not, we're changing things prospectively. We can't generally go back and unwind things that have happened. Most often we see a child has taken money from mom or dad, or sometimes it's a second wife or husband who have tried to alter an estate plan with any trying to get them more money. Most often that money is gone and you can't get it back. So we're really putting protections in place to stop it going forward. It isn't always gone, but if someone has taken money, most often you need to file a separate suit after getting a guardian to try to get it back from them, which again costs more money from a legal perspective. In guardianships, we can encourage or restrict visitation. Why would we want to restrict? Well, sometimes we have bad actors. We have people who are trying to get mom or dad to leave them more money or give them things. In other cases, we have a son or a daughter who moved in with mom and dad and made visitation with mom or dad very difficult. So we hash that out in guardianship court. One of the pros of guardianship, if you will, is there's an accounting of how income and assets are spent every year. At the end of a guardianship, you file what's called an initial report, which says what the person's assets are, and then you file every year how it's been spent. And that gives a much higher level of protection than a power of attorney. A power of attorney can account at any time, but it's not generally required. And more often than not, if it does happen, it's happening after death, and again, less chance to fix things. Occasionally, guardians become perpetrators. This is a very low percentage of guardians, but it has happened. I've seen guardians remove money for themselves out of the ward's account. There's virtually no chance that they'll ever get away with that, but it does happen. So the selection of a guardian is a very important part of the process. So I think moral of the story is be proactive, do a trust, do a power of attorney. If you have questions or you have concerns, use technology like EverSafe to monitor, have someone assist in paying bills, because it's much easier to avoid the problem than to fix it reactively. So we have a number of questions. We thank you for sending those out. So I think we're going to head that way now. Just ask. And if everybody could turn their camera back on, we'll get rolling on the questions.
All right. We have a number of questions thanks to our audience. Ray, this one goes to you. Is $250,000 enough money to engage a financial planner without having exorbitant fees eat up the account?
I would say yes. We are, more and more firms are not charging for financial planning services. So in our case, for example, at TD Bank, our typical client is $500,000 of investable assets. But I think there's other institutions that get lower than that. So I think it's a much more competitive thing. And when you offer advice to your client base, a lot of firms are doing it free of charge because they can either act as the investment manager on an ongoing basis or provide other advice as well.
All right. And we should mention that we're going to go a little long here to get all these questions in. Peter Strauss, if a Medicaid asset protection trust only contains the home and there is no cash in the trust, is it still an issue for a non-professional family member to be the trustee?
Well, it's much harder to steal real estate, notwithstanding the commercials abounding today in the communication world that title stealing is a big issue. It's really not. So I think the trust will protect the house, because now if it's over a certain value in all the states, it's state dependent. It may not be an exempt homestead. But I don't think you should leave the house in the name of the Medicaid applicant, even if it is exempt, if it's under that equity cap, because when they die, there will be a right of recovery because it's a probate asset. So trusts are not subject to the right of recovery rules unless there was some fraud involved. So certainly, I think the Medicaid Asset Protection Trust would be a good idea in most cases to protect the house from later claims. It would make you subject to the transfer of asset rules, however. So be careful that when you create a Medicaid Asset Protection Trust, the value of the future gift that will vest in the ultimate heirs of that trust will make you ineligible for a certain period of time. And now that applies to home care rules, if you make that transfer within 30 months of applying for Medicaid after October 1st, is going to be a serious problem. So we're warning our clients that don't put off the planning. If you think your parent or your spouse needs Medicaid, do it now and get that application in and hopefully get Medicaid approval before October 1st. But again, we're talking about financial abuse here, and make sure that if you're going to be transferring assets to children, or they're going to have control over trusts, that we put in the kind of protective devices that we've talked about here today, and perhaps using a program like EverSafe or Silver Bills, which in conjunction with good banking that Ray's talked about, these are safeguards. And I think the discussion today shows the truth and the necessity of this team effort. We are not alone, and we all have a role here to play. And we reach out, if the client calls us first, to the care managers and to Liz and to Marci and Ray, and hopefully they'll call us if they get the first phone call. But it is clearly a team effort.
All right, thanks, Peter. Now this can go to anyone. If for some reason APS cannot or will not get involved, and the client does not have capacity or willingness to recognize financial abuse, are there any other avenues to stop or protect them?
Well, certainly we can file a guardianship in that area if we need to. If there's actual abuse going on, or the whiff of abuse, you do have to be a little bit careful, because if you're wrong, you can, in the civil arena, you can be assessed legal fees if you file a guardianship and without a basis. But that tends to be the avenue. If you've called APS and they're not going to get involved, then you have to go the civil route.
Okay, Liz.
I'm not a fan. This is Peter. I'm not a fan of APS. They try hard. They're under budgeted. They're undertrained. They're overloaded. And if you call APS, make a referral to APS, it may be 6 months before any guardianship is instituted, maybe longer. So this brings us, and again, very quickly, because we don't have a lot of time, does the client perhaps have capacity to revoke the power of attorney or revoke or amend the trust? Capacity is not an on-off switch, and the capacity to revoke a power of attorney or amend the trust may take only very limited understanding of the problem. You don't need to understand how much has been stolen. If you may just need to understand that your agent has done bad things and you need to make a change. So that may be another remedy, depending on the facts. And I would always get a capacity evaluation from a trained physician to decide whether the client has capacity to do this. But that may be something you can do immediately if the client is willing. But sometimes they're afraid of the family member who has all that power. That's the physical and psychological abuse that we didn't talk about today. And they may not be willing to either acknowledge the thieving and the fraud or the abuse, or they're just frightened to do it.
Okay, well, this one could be directed toward Liz. Assume a gift card scam. Shouldn't there be some questions asked by the stores if a person purchases thousands of dollars of gift cards, or would this be something that EverSafe would catch?
We do have, this is something that EverSafe would catch. We do have a number of cases where gift cards were purchased. Sometimes you wouldn't believe the number of gift cards that are purchased. And yes, I agree, whoever asked this, that really stores ought to be training their personnel if something like that happens. I just have to add really quickly that I have great admiration for Adult Protective Services. And I know it can be frustrating, but they are under tremendous pressure on cases. And especially during COVID, you know, you never heard about personal protection equipment and the problems APS had getting it. And they're the ones going out to visit older people who are most at risk of having COVID. So I know it's frustrating. We have helped a number of our members walk through APS. I have called with them when they've asked me to get something done sooner. But and I know, Peter, I know you feel that way too, that they're tremendously overburdened. But I wanted to put that out there. And I also want to say, revoking a POA, I know there's a tendency to want to do this so that to stop the bleeding. And I know you know this, Peter, but I just wanted to add, if you have someone revoke a POA and there's any question about their capacity, you are deciding for the police and the prosecutors whether or not they can go forward with that case and how they can go forward. Because if the POA is revoked, then the defense attorney is going to say, what do you mean they didn't understand the transfer? You had them sign a revocation of a POA. So clearly they understood what was going on. And the police may say, or the police may be told by the DA, there's no criminal case. So, and I know Peter knows this, but I wanted to put that on after what you said, because revoking a POA, that was a huge problem sometimes for me as a prosecutor. But to the question, I agree with you. Gift cards are a huge problem. It's something that won't show up in your credit report. So while everyone's talking about freezing your credit or doing a fraud alert on your credit, you need to do holistic financial monitoring or you won't catch the gift card scam.
Okay, Marci, I have one for you. Has your organization ever encountered resistance from adult children when a client chooses to avail themselves of your services? If so, how do you address this? I ask because working directly with clients, I often find that adult children insist on taking over finances, even if the client would prefer that they did not.
What's interesting is what we've discovered in retrospect is that oftentimes the adult, you know, when there are many adult children involved and one is handling the household bill management, the one who's doing that and protesting the loudest is the one financially exploiting. So much as individuals and families outsource, for example, tax preparation to professionals, our message is you can outsource household bill management to professionals. And we're one of the vehicles to do that. And when there are professionals involved watching what's going on, oftentimes it's enough to stop some of the interfamily abuse and financial exploitation. But it happens, in my experience, when it happens, it's often because of financial exploitation. Typically, the calls we get from around the country are from the adult children who are the sandwich generation, who are working hard at their careers, raising their children, having this unpaid job of, taking care of their parents, and they don't care what it costs to employ us, and they just want to outsource this to trusted individuals. In the cases when they're protesting, unfortunately, it's often because they're perpetrators.
Marci, how do you handle the problem when you uncover some wrongdoing when you take over in view of your confidentiality requirements? I mean, how do you view your role there?
So it depends on the specifics of the individual and his or her signed agreement, jurisdiction. We have a provision in our agreement whereby we're allowed to provide access to our documents and records to third parties. So whether that person, signed that authorization, so I can't just blanketly say that. Whether the referral was made, for example, we had a referral from APS. And this is why EverSafe, and I feel sometimes like I'm a commercial for EverSafe, but like I say to everyone, why isn't everyone involved signing up for EverSafe? Why isn't every government, paying for this? Because, for example, with APS, it would be so much easier. We discovered that the caregiver had been going and withdrawing thousands of dollars from a cash machine with a case that we were referred to by APS. So
and we do work together. I should point that out.
Yeah,
We have a lot of mutual clients. As Marci always says, we're like peanut butter and jelly.
exactly. We recommend EverSafe to all clients. But so that being said, it's a case-by-case basis as to who we can alert as to what our suspicions are.
All
So
right. I got
Liz,
one
maybe
more.
we should go to the guardianship judges and say, why not hire a service like yours in lieu of having a bond, which could be extremely costly and eat up the guardianship estate?
Well, I've recommended Silver Bills to their guardianship project that we're working on. So stay tuned. That may very well happen.
All right, I think we have one last question.
Ray, does TD Bank have an issue if a customer with an existing mortgage with TD Bank transfers title of their house to a Medicaid asset protection trust? And if so, what steps can be taken to make the bank more comfortable with that transfer?
Obviously, a common technique. We get legal involved in that. We try to accommodate the client with regard. It depends on the factual situation. We're certainly not averse to it. And our first reaction is, let's try to make this happen. Let's try. We understand, why that strategy is being employed. So, and we try to make it happen. So, the best I can say is we try to cooperate to make sure it does happen.
All right, so I'd like to thank everybody. Great panel today, lots of good information. I think it shows you how much better it is to get out in front of the problem. I would like to note that we here at Pierro, Connor & Strauss are doing a webinar on the upcoming Medicaid home care changes and cutbacks. That's at June 9th at 11 a.m. Since you've just sat through the 25th Elder Law Forum, we'd like to say, remember us for next year. The 26th will be upcoming. There's a survey for you to fill out immediately following the program, and social workers have to submit your evaluations for credit. Thanks, everybody. Thanks for having a great Elder Law Forum.
Thanks, Aaron. Thanks, Peter. Thanks, Ray. Thanks, Marci.
All right, thanks, guys.
Thank you, everyone.
Stay safe, everyone.